I know. লাগবে তুমি পেয়েছো? পেয়েছো তুমি?
No, direction is if required and necessary, supernumerary post may be created for persons appointed in the interground. Is it related with our matter?
No,
Not related.
from the beginning we are saying that these are not related.
No, sir, just
Okay.
1 minute. Let me understand the judgment, whether there is any touch of supernumerary.
No, no,
in-
no.
For the original judgment, no.
No, that in the original judgment, no. Original judgment concerns a selection process not covered by this, the persons for whom we are appearing.
Don't repeat it. I want to know whether there is any observation regarding
Justice Boschak's judgment.
Justice Bosha's judgment. Anything in the original judgment?
No.
Take it from me, Milord. There's nothing.
Nothing.
Nothing. On the next day, order of 18th April, the part of CBI investigation that has been quashed. Said that the council of minister decisions cannot be a part of criminal.
Where is that?
That is Milord, 8th of April.
8th of April order.
ওইটা
হ্যাঁ এটাই।
ওটা তুলে দিন জজ সাহেবকে।
17th of April, there is another order.
Yes.
There's another order.
No, that is the subsequent order.
8th April order.
8th April টা জজ সাহেবকে দিন।
Original judgment is of which date?
3rd April. 3rd, with the original judgment, 8th.
Milord, 8th April, kindly the entire order may kindly be read, Milord. If it comments to your lordship, kindly. I handed over to your lordship on the other day.
So in the original judgment, paragraph 52, the court desired to deal with the issue of CBI
Separate.
inquiry separate, which is now court is dealing in 8th April.
The second page, I just point out only the relevant portion. The case was taken up by the cabinet and the decision was taken at the time as accepted when there was pending litigation in the High Court, and finding the tainted candidates by thorough examination was not possible. It is pertinent to note that while making out the case for the cabinet decision, the note specifically mentions the view expressed by the West Bengal Central School Service Commission, Kolkata, that there were wrongly appointed candidates, nothing to do with our case. No one has said so, by way of rank jumping, etc. And nothing was hidden. Having regard to the aforesaid discussion, we are of the view that the High Court was not justified in referring the issue of creation of supernumerary posts pursuant to the cabinet decision for investigation by the CBI. It may be relevant to take note of this clause 2 of Article 74 and clause 3 to Article 163 of the Constitution of India, which specifically states that the question whether any, and if so, what advice was tendered by the Council of Ministers to aid and advise the President, or tendered by the ministers of the cabinet or to the governor, shall not be inquired into in any court. Therefore, creation of supernumerary posts
No.
out of the
Sir, 1 minute.
yes, sir.
The challenge of the petitioners are the authority or the
Yes.
capacity of the state to create a supernumerary post in the facts of the present case. This is the challenge. Now, if this challenge transgress to the area where the Supreme Court has already expressed its opinion that this area cannot be subject matter of any inquiry before any court, then obviously this is a relevant observation. But if the petitioners restricts their claim or other investigation within the periphery, the state's capacity to create.
That the Supreme Court. So this,
Very well, you will obviously you will try to bring it within the
No.
sweep of these observation. Let him try, let him answer.
But, with due respect of Mr. Sengupta, the conclusion is that this order is only confined to the case of investigation, nothing more, nothing less. তুই আবার কি বলবি এখন? আমাকে তো বলতে হবে যাচ্ছে ডাকছেন বারবার তুই শুরু করবি নাকি শুরু করবো না হ্যাঁ শুরু করবি
What is the next order of 17th April?
that's not,
that is with regard to Milord
certain
the
directions are given.
that the
No, sir.
at the period by which the new selection process has to be completed
Filed by the CBI on other.
and
activities.
till then
Clarification is that it is
Nothing to do
CBI
with
and
this.
order-
That's got nothing to do
nothing
with
nothing to do with this.
nothing to do with this. 17th April is at the
যা যা
instance of
investigation অন্যান্য
মধ্য শিক্ষা
investigation
পর্ষদ who took out an application.
Supernumerary is not a
Acha. These are the all about the orders. These are the three orders have been
Yes.
passed. এই রিট পিটিশনটা দেখে
পারে না।
Marshal কিছু
এখন ওয়েবার শীত তো
Ordership. First, the subject is
স্টেটই
the-
প্রডিউস করবে
how many illegal are? I mean, this that challenge is failed. Unanimous. Because the intent. So, also, in respect of the detailed merit list intent, in respect of first levels. The notification.
First things first, not
who are you?
But I am one of the that intending candidate who could have participated in the Milord, the vacancies, Milord, which are created new vacancies, it ought to have been, Milord, kept wide open for all. It was only confined to a particular group, saying waitlisted candidate that there is no question of waitlisting in terms of rules.
Very well. So
So I am
you-
really questioning, Milord, the authority of the state to, Milord, create supernumerary posts under the garb of filling, Milord, the open post.
So you had participated in the
Yes.
selected, but you were unsuccessful.
No,
If
no.
we go by the 2016 result itself,
Now, in this matter, the petitioners are, Milord, not the participant in 2016 group.
yes, yes, yes.
Participant.
For work education.
For work education, participant. Now, when you
they
create,
participated in respect of the work
Work
education only or work education,
yes,
physical
work
education?
education, physical education.
Physical.
Work education and physical education? Or only work education? Please
Oh, no,
clarify.
both. Work education and physical education.
এটা only
Sir,
work.
please clarify.
Milord,
What-
work education.
Only work education.
No, work education.
Can I
Yes.
get a statement?
Paragraph 2 of the
paragraph
petition
two-
is only restricted to work education.
Paragraph 2 is categorical that the petitioners were applicant for work education at the upper primary level.
If that be so, Milord, there is no challenge. So far as the physical education part is concerned.
Same
Not
matter
that,
pending.
একই তো।
Same matter pending. since
এখানেই,
this is being
এখানেই।
heard. Physical educational matter pending.
Another writ petition is pending.
Yes, for physical education.
This
Now,
is
Milord,
before
it was
me.
not- Well, actually,
This
permits
is
me, Milord,
before me. Physical education challenge.
This is 2020, no, this is not hard in part since your lordship is only hearing.
to the
Assigned, this is assigned matter.
assignment.
No, no, এটা
Assignment is
assigned.
react for. Now, Milord, now the issue has become much more, Milord, easier for us. CBI has submitted a charge sheet that they have categorically mentioned that this post of physical education, work education have been sold in the market. Yes, kindly see this supplementary affidavit.
So you are using a supplementary evidence.
Affidavit, Milord, annexing the,
But Is it for work education?
yes, yes.
এই দাও তো সুদীপ তো আমার কপি দাও।
And so for the physical education,
Physical education, work education, Milord, are the same group.
তোমরা এখন add হওনি।
আরে দাঁড়াও না। এই স্টেট কে দাও?
হ্যাঁ,
স্টেটের ডকুমেন্ট দাও।
আরে, স্যার, আর নেই copy, স্যার।
আমাদেরকে কপি দিবি না, we are already parties.
না, already not hard.
Soft copy দাও, printer খরচা দিবি।
Now, if you come to your prayer,
My lord. That I am making a prayer for publication of OMR sheets. That's the most transparent and fundamental issue. If the OMR sheets are published, not automatically the results should be apparently clear to the court. Our prayers are, my lord, multiple prayers in the petition.
now 2016 selection process, the entire selection process has been quashed.
No, not this process.
Wait,
The entire selection process, my lord, has been quashed for Group C, Group D, 9, 10, 11, 12 teachers.
Group C, Group D,
Group C, Group D, non-teaching staff, and teachers for class 9, 10, and 11, 12.
please show me from the order.
My lord, kindly.
Just a minute. Show me the order and
Judgment
the
of Supreme Court.
recruitment advertisement
Yes,
was common or separate for work
separate,
education?
for this separate.
For this separate. Please clarify this.
That kindly takes up, my lord, the order of the Honorable Supreme Court, 3rd of April.
Yes.
Status of the petition.
না না, এটা অন্যটা ওই শুধু তো দিয়ে দেওয়ার কথা Milord, kindly come to Milord the judgment of the Honorable Chief Justice. The impugned judgment dated 22nd of April, our block sets aside the 2016 selection process conducted by the West Bengal Central School Service Commission for the recruitment of non-teaching staff in groups C and D and assisting teachers for 9, 10 as well as 11, 12. This is the issue. And the entire thing was set aside.
Now, then show me that this work,
Work education is
was a-
separate.
was a
Yes,
separate
kindly-
advertisement.
Kindly come to Milord, the advertisement. ও আচ্ছা, annex করোনি? Advertisement টা দাও তো। এমনি দাও না আমাকে advertisement.
I cannot see it in that way. Give me a copy if it
I'm
is
just-
not part of the record.
Milord, this is a part of annexure of Can 8, but anyway, Lordship can look at it. Annex টা দাওনি কেন? Supplementary দাওনি কেন? একদিনের মামলা হচ্ছে। লেখা যাচ্ছে। হ্যাঁ,
তুমি কোন জায়গায় দেখাচ্ছ সিবিআই বলেছে
করুন প্যারাগ্রাফ
Page 9.
ওইটা কোথা গেল?
Page 9.
Supplementary.
পেজ
Page 9.
জজমেন্টটা দেখাবেন ওটা দেখাবেন সুগত যেটা একটা দেখাবেন
কি? এই অ্যাডভার্টাইজমেন্ট ওখানে আছে? তাহলে কেন বোকার মতো কথা বলেন?
এটা একটা সেপারেট জেরক্স করে দেবেন আমাকে।
এটা ও জানতে চায় সেই উত্তরটা দেবে, বাড়তি কথা বলবে না।
Yes. This is therefore,
This is a separate advertisement, separate recruitment process, separate way of dealing the scam, but in a similar manner.
very well. Now,
Now
a
kindly
list
takes
of-
up the supplementary affidavit, just now I have filed. This is very important. Now your lordship will find the similarity, if not identity with the 2016 selection, which was quashed. Page 19 of the supplementary affidavit.
Motion. We come to
The paragraph 17.13 of the charge sheet says, well, may I read out in court? Investigation has also revealed that Arun Kumar Hajra, alias Chinu, was an agent of accused Sujoy Krishna Bhadro and had collected about 78 crores from the undeserving candidates of primary teachers, upper primary teachers, Group C, Group D assistant teacher, 9, 10, organizer primary, real, physical education and work education.
Hmm.
Through his sub-agents and had delivered it to Sujoy Bhadro, directly to Nikhil Hathi as per the direction of Sujoy Bhadro. It has been further revealed that out of rupees 78 crores, 11.50 crores was paid towards arranging of appointment as primary teachers. But therefore, the allegation of corruption, my lord, is also, my lord, very apparent and pertinent to the issues pending before my lord, apart from the constitutional issues. Well, I would rather appeal to your lordship, my lord, kindly decide the matter as a constitutional and administrative law issue, and then, my lord, the corruption involved, how it was done, and to
No.
make it that, my lord, beneficial for everybody's to understanding, the waiver must be produced before the court.
Sir, one thing, after the Supreme Court judgment, the Supreme Court has clarified, the clarification is that
Kindly excuse me, my lord, this fan creates problem for me. I'm just wearing the hat.
you look nice by the hat.
At least when I said so, you will not blame us. আমরা টুপি পরি
না না আমি নিজে পড়ে দিয়েছি নিজে পড়ে
Himself, by he himself has done it.
That's right.
Where is the cabinet decision?
And do not in any way impinge or reflect upon the investigation of charge sheet filed by the CBI on
Or
other
otherwise.
aspects. So, sir, after this observation that it cannot be looked into,
Or other aspect.
this observation whether really any have impact on this charge sheet or the criminal investigation,
That therefore the investigation is going on. I am not
can
only-
it be?
I am only, my lord, pointing out to honorable court that this recruitment process, which is now before your lordship, also comes within the purview of scam and corruption. So one
Wait,
point.
but even
Yes.
if it is done,
No, lordship need not go into the question of investigation. I am not on that.
yes, that.
I'm not on that. Probably I'm, but I say that to fulfill that purpose, my lord, since we had prayed that the Weimar publication is very important, our basic allegation was manipulation in Weimar, and to give them the protection, these numeric posts are created. These are all correlated. And then the question is, can the state, even the President of India cannot, my lord, act beyond the rules and the constitutional provisions, settle judgment of the Supreme Court. Therefore, this cannot be said that the cabinet decision, therefore you cannot touch us. That might be the one of the argument I'm apprehending. And
Cabinet
therefore-
decision which cannot be touched, as the Honorable Supreme Court has also held.
Supreme Court did
Therefore-
not held it. Supreme Court just quoted the provision of Constitution and said no criminal investigation. Supreme Court did not declare that these issues cannot be gone into, because even the cabinet memo, it says subject to pending writ petitions.
Not shall
That
not
was
be
also-
inquired into by any court is the observation.
That's observation, but I will
Kindly cease.
this observation will not
That-
cannot.
The aforesaid direction is therefore set aside.
Aforesaid
Cannot
direction is
be,
investigation.
cannot be inquired into by any court. What is that?
That means the
Propriety
cabinet.
of the cabinet decision.
No, no,
Propriety.
investigate.
No, no,
It
with
must relate to the investigation. The
No,
court
with
says that.
respect. With respect, no. Kindly read the last
No,
portion of
yes,
the
yes.
order where the Supreme Court is
Yes,
referring to the
also-
Constitution.
May I read out, my lord? Let us get ourselves clear. In paragraph 2 of the judgment, it was held that the issue with regard to the direction for investigation by CBI. That order of the court should be read in its entirety. In first page, in paragraph 52 of our judgment, dated so and so, it was held that the issue with regard to the direction for investigation by the CBI vis-a-vis the decision to create supernumerary post would be dealt with separately. Therefore, this creation of supernumerary post vis-a-vis CBI investigation.
That this was the issue framed by the Honorable Supreme Court to be investigated separately. Now, while dealing with it,
Let me
what are
place
the
it-
observations?
let me place it. In particular, our attention was drawn to paragraph 257 and 265 of the impugned judgment. 257, 265 of division bench judgment category case, they must take them into custody if necessary and carry on investigation. Therefore, the Supreme Court was again confining its decision making with regard to those two paragraphs. Then case says, we have considered the observations made in the aforesaid paragraphs on a pointed question it is accepted that in the writ petitions, no specific prayer was made challenging the cabinet decision, but this petition now challenge is there. Consequent to which order dated 19th of May 2022 was issued by the government of West Bengal after approval of the governor. No prayer was made that this order should be made the subject matter of any investigation. Look, as you see, this is not without any other aspect of constitutionality. Any investigation by the police or the CBI. Perusal of the note dated so which makes out a case for the cabinet decision reflects that it was recorded under power under section 19 of the West Bengal School Service Commission Act may be used in respect of waitlist candidates. But the same shall be subject to the outcome of pending litigations before the High Court at Calcutta.
Section 19, please.
Yes. Now, that I have annexed, Milord, these rules are annexed. Section
No,
19.
Section 19 is in the.
Is Milord the
You are showing charge sheet it specifically indicates money trail on
even on this,
this work education and physical education.
even Milord, in this matter, Milord, we did not have any idea that this matter is also a part of money trail or scam. That we come to know gradually when the charge sheets are filed. Therefore, the issue of constitutionality remains to be decided, which the Supreme Court did not touch and could not touch, because Supreme Court says we are confining only to the issue of direction by CBI, as direction by the court to CBI, nothing else.
Regarding the creation of the
Supernumerary
ministers,
post.
councils of ministers advice
Ah.
for creation of the supernumerary post.
Now, Milord, let us go by the law.
Now, the what is you have supplementary affidavit, you have
Supplementary, I wanted to show, begin notice of the court, that even this recruitment, which was not really before the Honorable Supreme Court, is part of the scam.
The contrary argument was being advanced all throughout. All throughout. Milord, your lordship was, Milord,
No, either-
persuaded.
Either I finish or let him start, or let him complete, I don't mind. Let us go one by one. Let us not follow the bad example of Supreme Court. The 5 lawyers will shout at a time.
No one is shouting. We are just
The shouting
pointing out.
means, shouting means,
Milord, without meaning any disrespect to my esteemed senior, Milord, the
let us proceed.
endeavor was
I invited you.
very.
Now, what is the impact of it? Now, you are, if you go by your prayer,
Yes, kindly come. My prayer belows A,
any allegation of any money trail or
It's not there.
illegality in the
we have
pleadings?
mentioned. We have mentioned, but Milord, we could not give any material to support.
Very well, any pleadings to
Yes,
that
yes, yes. Kindly come. Kindly come. That is there. Well, a very short petition, Milord, may I just place the relevant portions?
purpose to absorb the waitlist state candidate. I want to know from you to correlate with the observation or the finding of the CBI charge sheet. Is there any allegation in the writ petition that the waitlist state candidates are also tainted?
No, Milord, I have said so. Kindly, once again, may I read out the paragraph which I have read out?
Paragraph authority of this state.
No, paragraph 5. I started from reading from paragraph 5.
That is, they have been given appointment.
Yes, no, and with the several candidates, paragraph 5 will not continuing. It is stated that several candidates who have been given blank OMR sheets have been empaneled. It is further stated that in the aforesaid selection process, merit has been compromised. But from my end, I could not get any better Milord information because RTI information have been refused to me.
Subsequently, to justify an action which was not.
This is for challenge, to throw challenge to the entire selection.
Yes, yes.
Now, his initial writ petition, as I could gather, was that state cannot create this post. In a given situation, state can, but this is not a situation where state can. This was the.
But we'll address your lordship that whether, Milord, my learned friend's client can invite the court to go into that.
Very well, we will.
Yes.
Now, the